Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining us for our regular Wednesday evening Pacific time, Los Angeles time, where I'm located, live on June 9th. Usually we start at 5 p.m. Pacific, but every once in a while just start early to get your questions in, especially when we have good news which came out today. Today's the annual conference for immigration lawyers. I was speaking at it today, and it's an annual thing where USCIS announces like a big major change always on the first day of the conference. And wow, what a doozy the information for today. Very helpful for people. Good to get into that second, but before we start, I want to remind those watching live, one, we have a free or 3 or 4 free consultations we give out to those who watch live. Every 10 minutes, my assistant will tell me, okay, this person won. What you got to do is click like, subscribe, and leave a comment to let us know you want a chance at the consultation raffle. And every 10 minutes we'll announce the person. They got to take a screenshot of their page to show that it is their account and to email it to me, and we'll take it from there. Other than that, if you're interested in a marriage-based kind of case, fiance marriage case, download the Ultimate Marriage Green Card Guide for free. It's the ultimate guide out there that really breaks down the marriage green card process. For you, it's fantastic. If you read it, you'll really see what I'm talking about and appreciate it and be like, wow, that's something. So with that, let's get it started. All right, so as questions are trickling in, we're going to get into a second. I want to mention a couple of things that has happened with USCIS that was announced today. The big important one, I think that affects a lot of people, is the work permit issue. So what happened is USCIS issues a work permit usually for a year when you're filing for adjustment of status. That's when you apply for a green card under Regulation 245. Those run out after a year, but in many cases there's super amount of delays happening, which is very frustrating. They announced today that instead of giving a 1-year EAD, Employment Authorization Document, or work permit, they're going to give a 2-year EAD to hold you over, not have to refile and deal with that hassle again. So that's good news. Secondly, during the Trump administration, there was a memo that came out that said if you didn't submit all the proper document on the first try when you submit your case to USCIS, then what they're going to do is just deny your case, and that's that. So that was really problematic, troublesome, because people sometimes mix up. Sometimes USCIS makes a mistake. You sent something, but they claim that you didn't, and based on that alone, they could deny your case. Now, thankfully, they walked that back. They've renounced that memo that says they'll automatically deny it, which is a big help for people, especially doing it on themselves. Mistakes do happen, so we saved ourselves from that one. That's the second thing that they did. And the third thing, it's not as big as these for at least the stuff we do, but they clarified and updated the standards for getting an expedite request. So this is when something's taking a while at USCIS, or you need it done faster. You tell them, hey, I need to expedite my case, make it faster. Now, what does it mean? They broadened it up a little bit, but practically speaking, it's always up to the adjudicating officer at USCIS what they want to do, and they're not always consistent in how they're doing their stuff. They're not always as open in accepting an expedite request. I've had some expedite requests recently which were really good cases. I mean, these are cases where I'm like, oh, this is going to be easy, open and shut expedite approval. This is going to go in. But they were both denied for really heart-wrenching conditions, and we're complaining to senators. They told the senator we're not going to do anything. So we'll see how good the expedite request is. I'm not going to hold my breath, but it's all indication of more positive stuff, especially relative to the previous administration as to how bad things were. Peter Ibrahim, I think in regular as well, asks, how long does a diversity visa lottery adjustment of status process take from biometrics to interview? So there are no fixed times where in any immigration, essentially how long processing takes. In particular, biometrics to interview. This is a question that comes up every day for me is, I got my biometrics, how soon do I get an interview? How soon do I get approved? There is no correlation between biometrics appointments and getting an interview. The biometrics appointment is an automatic thing that gets scheduled on some sort of system, and you go there. There are times when we get no biometrics, you go to the interview, it's rare, but they say, well, your interview went well, but we still haven't got your biometrics. So they're unrelated as to what I've seen at least. So it's not something I would think about, oh, I got my biometrics, that's a good indicator of this or that. It's just a formulaic thing. They have a place in line for getting biometrics, and that's about it. Now, for adjusting status for diversity visa cases, you have to get your case done before the end of September of the following year after you're approved. If you don't have it, you unfortunately lose out on the process. They do try to expedite those kind of cases because there is that deadline, but there's a lot of luck that goes into it as well. Law asks, I was pending asylum and I won the diversity visa lottery in 2021. I filled out I-485 and got denied because the officer said pending asylum is not status. What should I do? Well, Law, which field office did you go to? Where did your interview happen? This is a major issue, and this is something that actually comes up a lot in these Q&As that we have. So let me know what city you filed this. But let me talk about this. I have a lot of videos and clips on this on the YouTube page, on the JQK Law YouTube page, on the clips page. But essentially, if you file for file for asylum, you're not in any status. And to be able to file for adjustment of status, which means going from whatever status you had to a green card to adjust to that, you have to have some underlying status. Now, a lot of field offices where you do your interview, it will not consider it a status if you had valid status. You're a student visa holder, you are a tourist visa holder, or something like that, and you file for asylum, and those tourist visa or the work visa or the student visa ends, and you have an asylum case pending, they don't consider that status. So in this case, you said Detroit field office, they will not accept that and will deny your adjustment of status case. However, I've seen cases in some field office will accept that. This is a situation where if you have the funds, try filing a lawsuit. It's hard for the diversity visa lottery because the numbers run out. They may not accept a lawsuit on it, but it's something that is case by case basis, office by office, whether they'll accept that. Some arguments, again, some offices work, some don't. And it seems right here, Detroit field office doesn't work. In Virginia, this doesn't work as well. I've seen it work, but there are a couple of field offices where I've seen it work. And the field office you have your interview at and makes a final decision on your case depends on your address. So this is a big, big problem. There's a lot of lawsuits that come back and forth on this. But we don't have clarification. What I've seen is it's a case-by-case, office-by-office answer to this one. But sorry about the denial. Paranoid Android asks a regular, if one holds a valid EAD derived from F1 OPT, so that means you're a student visa holder, you graduated, you get a work permit for a year after graduating, and you get work experience. And you say in the meantime, is approved for change of status to an O1, is the F1 EAD still valid or does it become unusable in a new status? So yeah, it's not usable anymore. So this person has a student visa and then changed to what's called an O1 visa. That EAD immediately becomes expired or unusable because the basis of it was your F1 status. You no longer have F1 status, you're an O1 visa holder now. So anything that was attached to that goes away, now you have the O1. Now the O1 allows you to work based on what your itinerary is and how it was described, the things you can work on. So it could be a lot of stuff you do, it could be a few stuff you can do. It depends on how you worded and how you broke down your itinerary of work for the O1. O1 being an extraordinary ability visa, you have some sort of skill that you're top at, and based on that you're working and pursuing and continuing your work in the United States. So just to underline question, the EAD is not valid, but hopefully you design the O1 in a way that's more able to accept other things that can be helpful. Sabrina asks, when going through consular processing for someone who entered the US without inspection, will we ever have to go to an interview again? I never see it mentioned. Well, if you're going to go through consular processing with someone entered without inspection, consular processing is when you have to go to the embassy. Well, you may be subject to a 3 or 10 year bar, so you need to make sure you got a waiver for that. But will you have to do an interview again? Well, you will. Consular processing will end in an interview. If the interview doesn't go well, sometimes they'll ask you to come again. So there's just so many different things, Sabrina, could happen here. It depends on the facts of the case. For example, you may go to the interview and they find some sort of other inadmissibility issue. They might say, oh, you have marijuana, you're a marijuana user. You have to come back in a year and show us that you've been marijuana clean and you went through counseling, all this stuff. You have to do another interview at that time. So it's just too much going on. That could be possibilities. That it's way too hypothetical for me to be able to answer that, Sabrina. But it may be possible where you have to do multiple interviews depending on the details of your case. Mohammed follows up, is asylum-based green card any different than a marriage-based one? I don't mean the process and file, officially indifferences. Yeah, so a marriage-based green card is adjustment of status based on INA 245A, or 245, let's say. An asylum-based green card is based on another code section. I don't recall what the number is exactly. I don't know, 217 or 2 something, I don't know. So they have different nuances to them and what they mean and could do. It's too technical legally, but there is that much of a difference. Like when you get the green card, it'll indicate how you got your green card, what the basis one, which will identify you're an asylee too. Practically for what your life is not going to make a difference, but there are technical differences that are too technical to be able to make a difference here. Bilal asks, hi, I was told by an accountant to file my taxes under single as my wife lives in Canada and she doesn't have a social security number. Is that okay? Will that apply for my US citizenship when I apply for US citizenship? In general, it's probably going to be okay, but that's not right. Your accountant is incorrect. What I found is most accountants are incorrect on this. Just because your wife lives overseas doesn't mean she can't be included in your taxes. You could file for what's called an ITIN, I-T-I-N, but ideally, you just want to file for her status. So, first of all, you don't want to lie to the IRS. You are married, so you have to file married, filing separately if your wife's not filing with you. Maybe try talking with another accountant for proper information. The other accountant will probably give you mistaken info too, because what I've seen is most accountants give this incorrect information, but you should include her. There are ways to submit the case by paper, even if you don't have an ITIN, just to get it in. And for citizenship, it's probably not going to be a problem either way, but if you're going to file for your wife's green card and then want to look at tax returns, that could be a problem. I haven't seen it be a problem. They let it go because most people don't know what to do here, but it's not the proper thing to do, and as a professional service person, they're not supposed to give you bad advice just to make their job easier. They should just tell you, or at least study what to do this properly. So I wouldn't go by what that accountant said, no. Peace for all asks, can I enter the US on a B2 visa and get married to a US citizen and return to my country and wait the process? Yes, technically you can, but we don't want you, if, for example, if you haven't got a tourist visa yet and you go to the embassy and they ask you why you want to come a tourist visa, you have to be honest. So if you say, hey, I want to marry my girlfriend, my fiance, and then come back for consular process, you have to tell them. So if you don't tell them, you come and get married and go back, although you didn't stay, which is what they're worried about, they could come back later and say, oh, you lied to us at the interview, you didn't tell us you're engaged. And so that's misrepresentation. So can I enter the US? This is I can't individually answer this, I have to see what's going on, but generally, you gotta be careful and do this kind of stuff. You should consult with an attorney in private to see what the whole facts of the case are, to see if that's appropriate or not, and how to plan it out, maybe working with CBP Customs ahead of time, planning out getting the visa, all this kind of stuff before coming. So definitely consult with an immigration attorney. FPL asks, hi John, can I apply for STEM OPT and I-130 simultaneously? Yeah, they're kind of separate things. The I-130 is the I-130, OPT STEM is OPT STEM. You should do both. I mean, again, with these individual kind of cases, this is general education only. Whether you could apply, I don't know. I don't know if your I-130 is proper. I don't know if your STEM OPT is proper. But generally, it can be done. Whether you could do it, I can't say. It's all just general education and knowledge. Bill follows up, thanks. How can I get the right number of days outside the United States? Do I need to subtract 1 day from the total of days between 2 days, or subtract the day left and the day came back? Bill, if you're thinking about filing for US citizenship and you're counting the days, which is I think what you're talking about, any day where even partially you spent in the United States is considered a whole day here, and then the days you're fully outside is fully outside. But if you're trying to count this for the physical presence requirement, that's that. But if you're trying to count this for how they're going to deal with you at the airport when you come back in, at the port of entry, or even on citizenship to see whether you're actually in or not, that kind of stuff doesn't matter. They look at the whole picture of where you've been and what your history is. So you should talk with the immigration attorney to see how the whole thing looks like. Opad asks, can a small business owner sponsor an F1, F2 visa holder for H1B? Yeah, it's possible. Anyone could do an H1B if an employer can. It really depends on if you could, pay the amount you got to pay the person, their education is proper for it, and if you win the lottery. So this F1B student, unless you're a research institution, which I doubt you are, you have to wait until next year in March, April to file. So this person needs to have their F1 status valid or OPT status valid until that time, so you can file for the H1B for them and take it from there. It is possible. The size of the business isn't necessarily a bad thing. The smaller it is, well, the more they may question it. But if it's a business and it's running, it's not the worst. It's doable. But it's just a lot of factors, and the wait and the delay is something that's problematic. So that's something to think about. I'll go ask, historic median processing times on USCIS website, are they correct? It's not historic, it's what they consider to be processing times. It's a very stupid formula they have, how they calculate it. It doesn't make any sense, and it's not connected to reality at all. But if you want some made up timelines, yeah, go to uscis.gov and you can find them there. But it's not something realistic. We have to use this sometimes if we're filing a lawsuit or if we want to file a complaint. But for practical purposes, it's not something I check on. Clients do because they think there's value to it, but there's no value to it. Alright, so with that, I think we're going to call it a day. Thank you everyone for watching and tuning in today. We started a little bit early, so we ended a little bit early as well, but I appreciate everyone who joined. I guess we'll get one last question, but before that, if you were interested in a marriage green card case, download the Ultimate Marriage Green Card Guide by going to marriageimmigrationlaw.com, download it there. And we're always here every Wednesday, 5 p.m. Pacific time, taking your questions, so tune in on all the different apps. Alright everybody, until next week, God bless, be safe, and we'll see you soon. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.